Good afternoon, everybody. Good afternoon, everyone. No, thanks. Is this working? Is this working? Hi? No. Antonio? Oh, is this working? Ah, it's working now. Ah. Hello, good afternoon. You can't hear me. Should I sit at one of these microphones? Yes, because they can't hear. So good afternoon, everybody. For those of you in the main hall, could I ask you to wear headsets, please? Thank you. Distinguished guests, ladies and gentlemen, welcome to the special event to celebrate the 40th anniversary of the United Nations Convention on the Law of the Sea. To begin proceedings, it gives me great pleasure to invite the Secretary-General of IMO, Mr. Ki-Tak Lim, to address you.
I believe you had a very heavy, long day until now. Chair, distinguished delegates, ladies and gentlemen, it is a great pleasure to welcome you all today to mark 40 years since the adoption of the United Nations Convention of the Law of the Sea in 1982. You will shortly hear from our esteemed panelists who will guide us through the past 40 years and look ahead to future challenges. Over the past 4 decades, many of us have participated in work that implements the linkage between UNCLOS, which is rightly described as the Constitution for the Ocean, and the treaty regime of the International Maritime Organization, which set a legal framework for the ships that ply those oceans. UNCLOS established a framework for how we relate to our ocean by regulating the rights and the duties of a state of their use of the ocean. UNCLOS enshrined the fundamental principle of freedom of navigation and obliges flag states to ensure that navigation is conducted safely and conform to generally accepted international regulation and practices. IMO, of course, was established some years earlier in 1948 as the global standard-setting authority for shipping. By 1982, IMO had adopted a comprehensive body of international conventions covering safety, efficiency, and environmental performance of international shipping, as well as search and rescue, liability, compensation. Later, mandatory maritime security measures were adopted. That is why many articles in the UNCLOS refer legal frameworks developed by the competent international organization. States negotiating the constitution for the ocean recognize IMO's role and experience in this area. IMO treaties are referred to in many provisions of UNCLOS. Ensuring the safety of ships, navigation as well as seafarers and the passengers through global standards for ship design, construction, equipment, operation and crewing, but also seafarers' qualification and training, safety management and operation remains our top priority, and we are constantly enhancing our safety-related instrument. IMO is guiding the future of shipping by addressing new challenges. IMO is supporting sustainable development by enhancing shipping's contribution to global mission to combat climate change, as well as move toward a digital future by enhancing the automation and digitalization of shipping. Of the more than 50 conventions adopted by IMO, over half directly relate to environmental issues. Part 12 of UNCLOS imposes on states the obligation to protect and preserve the marine environment by cooperating on a global basis, including through competent international organizations such as IMO. IMO measures have been enhanced over the year, contributing to the continuous and further greening of the shipping industry. In fact, many of IMO regulatory advances have paved the way for and catalyzed technological developments and innovation to tackle today's challenges, from ballast water management and preserving biodiversity to energy efficiency. IMO is committed to ensuring the maritime sector plays its part in meeting global ambition and the goals tackling the climate change crisis. A comprehensive set of mandatory measures have been adopted to improve the world fleet's energy efficiency. The initial GH strategy will be upgraded by middle of 2023. IMO member states are already discussing incentivization and alternative fuels and innovative technologies. By embracing innovation and technological development, shipping will remain unchallenged as the main carrier of global trade. Shipping needs to be supported by the regulatory framework that facilitates the highest possible standard. A greener, innovative, and more efficient maritime sector is essential if we are to meet our global ambition and goals to secure the needs of future generations. Most of IMO 175 member states are also parties to UNCLOS. IMO will ensure the harmonious coexistence between the law of the sea and the maritime legal framework continue for the benefit of ocean and the whole mankind. I'm very personally pleased to organize this one in commemoration 40th anniversary of UNCLOS. There is a strong connection, as I mentioned, between UNCLOS and IMO, many IMO conventions. And luckily, we invited very renowned speakers, and also, someone who knows here, as colleagues working maritime diplomat, but very senior, like the speakers, panelists from the UNCLOS based in Hamburg. So I'm very pleased. And also here, I know the former director of the International Maritime Law Institute. So today, I believe you will have a very informative knowledge and information which would be relevant to our work. So today you had a very busy time to 4 p.m., but I hope we enjoy this conference and followed by very relaxing reception on the delegate lounge. Thank you very much.
Thank you, Secretary General. Ladies and gentlemen, today's panel will be moderated by Mr. Fred Kenny, the Director of IMO's Legal Affairs and External Relations Division, and Mr. Otter Losz-Szyminska, the Head of the Legal Affairs Office of IMO and the Deputy Director of IMO's Legal Affairs and External Relations Division. I now invite Mr. Kenny to proceed with the first panel.
Thank you, Tamara and Mr. Secretary General. Distinguished delegates, thank you for being here with us today to commemorate UNCLOS's 40th anniversary. I would also like to welcome those who are participating in this event remotely, as well as those who are watching it streamed live on our YouTube channel. 40 years is an important milestone, a timely opportunity to reflect on UNCLOS's trajectory and to look at it from different perspectives, particularly the IMO perspective. As the SG mentioned in his remarks, IMO has played a tremendous role in the implementation of UNCLOS, bringing the words into action. These panels will give us an opportunity to see where we have been and where we are going. One housekeeping rule, there will be a Q&A session at the end of this, time permitting. I intend to keep the speakers to time so that you can ask your questions at the end. But that will occur after both panels have been concluded and all speakers have had an opportunity to speak. To save time, I'm going to introduce all 6 speakers now, and then we'll be able to go directly into the second panel without additional introductions. Our first panelist is going to be Mr. Vladimir Yaris, Director for Oceans Affairs and Law of the Sea of the Office of Legal Affairs of the United Nations Secretariat, who's dealt with many issues, and really we're happy to have him here. He just flew in from New York today, and it will be great to get his perspectives from the top looking down. The next panelist is Ms. Fernanda Milique, Permanent Representative of Argentina at IMO, who's a familiar face to all of you in this room, a career diplomat who has specialized, among other matters, in the law of the sea, particularly at the United Nations in New York. And our third panelist will be Judge Thomas Heider, Vice President of the International Tribunal for the Law of the Sea, who's had a distinguished and extensive career in public international law and ocean affairs, and can give the UNCLOS perspective on the relationship between IMO and UNCLOS. For the second panel, we're privileged to have with us today Judge David Attard, former director of IMO's International Maritime Law Institute and the winner of the 2021 International Maritime Prize, and a current member of the International Tribunal of the Law of the Sea, who will be giving us remarks on what he views as the future of the relationship between UNCLOS and IMO. The next panelist will be Professor Malgosia Fitzmaurice, who holds a chair of public international law at the Department of Law, Queen Mary University in London. She specializes in international environmental law and the law of treaties, and will be discussing those matters with us today, and we're fortunate to have her here with us. And finally, our last panelist, who will be participating remotely, is another face who is well known to us, Ms. Gillian Grant, the current chair of IMO's Legal Committee, and also having served as Canada's alternate permanent representative for the last 5 years. And she will be giving perspectives for the future with some of the challenges that we're seeing in the relationship between IMO and UNCLOS for the future. Now that you have met our panelists. I would like to move to our first panel discussion, and really, without further ado, invite Mr. Yaris to take the floor. And you have the option of the podium or the floor, your choice.
Thank you. I think it might be more convenient if I speak from here, if with your permission, Frederick. Thank you very much, Mr. Secretary General, distinguished representatives, ladies and gentlemen. First, allow me to thank the International Maritime Organization for the invitation. It's a pleasure to be here. I'm here also on behalf of the United Nations Legal Council and Under Secretary General for Legal Affairs, Mr. Miguel Serpa-Soares, who has many roles in the field of the oceans. And not only he's overseeing the work of our division, which is the de facto secretariat of the United Nations Convention on the Law of the Sea, which celebrates its 40th anniversary, and the Constitution for the Ocean, but also he is the Secretary General of the so-called BBNJ Conference, which is the conference on the international legally binding instrument under UNCLOS in relation to marine biological diversity of areas beyond national jurisdiction. And also, he oversees at the focal point the work of the UN Oceans. And the UN Oceans, it's a mechanism for coordination and cooperation among United Nations agencies, programs and bodies. And IMO is a very active member of that coordination mechanism. So this, in a nutshell, opens my brief talk about the convention. And of course, the 10 minutes that are allocated to me are not giving justice to this treaty, which is the Constitution for the Oceans, had a very complex treaties of 320 articles, 9 Annex 6. But of course, we know that the Convention has played already an immense, tremendous role, which is hugely underestimated. And this is the contribution to the maintenance of international peace and security. This is one of the most important contributions of the Convention. And this is, of course, based on the principle that the Convention itself, it's a convention for peace. It's for peaceful uses of the oceans, and to support cooperation and friendly relations among all nations in conformity with the principle of justice, equal rights, and the promotion of the economic and social advancements of all people of the world in accordance with the purposes and principles of the United Nations Charter. So that's why, of course, states are very keen on maintaining and keeping this treaty not only alive, but also and implemented, but also maintaining its integrity. Because the convention is of strategic importance for actions for states. It's a basis for the action at the national, regional, and global level, and also a basis for cooperation in the marine sector. That's why the integrity and the universal and unified character of the convention is of so paramount importance. In fact, of course, the convention as a framework convention also is the basis for action by states in promoting, not only promoting, but in going ahead with implementing the goals, sustainable development goals of Agenda 2030 for sustainable development. And of course, you know that there is a target 14C, which relates directly to the implementation of the convention. Of course, we all know that the convention is a package deal, a very fragile package deal, but a very important package deal, which is a result of balancing the interrelationship of so many different issues. And of course, many of these issues were quite conflicting. And of course, freedom of navigation was one of these issues, which is very carefully weighted in the convention in the terms of maritime spaces. There is only one body at the global level which has the power to and have the competence to annually review and evaluate the implementation of the convention, and this is the General Assembly of the United Nations. It does so every year, of course, in the context of the discussions. This year, it will devote 2 days in 8th and 9th December, that means next week, to discuss, to celebrate the 40th anniversary and to discuss matters pertaining to oceans and all the sea and sustainable fisheries. And of course, the General Assembly also adopts annually 2 resolutions. And now I'm talking about these resolutions because in addition to the convention, which recognizes the role of IMO, of course, as the competent international organization in connection with the adoption of shipping rules and standards concerning maritime safety, efficiency of navigation, and prevention and control of marine pollution. But the General Assembly does the same. Not only that, but it contains many paragraphs which are relevant to the work of this body. And I've done some very quick count before coming here. There are about 50 paragraphs of the omnibus resolution, so-called omnibus resolutions, out of more than 300, close to 400, which mentions International Maritime Organization. This is a very significant number. Also, the resolution on sustainable fisheries has at least 9 to 10 paragraphs also referring to International Maritime Organization. So this only shows that there is a certain degree of importance attached by member states at the highest level by the General Assembly to the work of this organization. Of course, one of the most sort of prominent issues in recent years, besides, of course, the impact of the COVID pandemics on seafarers, were issues related to piracy and maritime safety and security. Actually, as recently on 22nd November 22, the Security Council of the United Nations had a briefing on piracy and armed robbery against ships in the Gulf of Guinea. Of course, the IMO, I don't have to tell you that the role that this organization plays in this field of suppressing illicit crime, suppressing crime and illicit actions, including piracy and armed robbery at sea. Of course, the General Assembly, besides its own discussion during the main part of the session of the General Assembly, which is going right now, is also annually focusing in the context of the informal consultative process of topics, and many of these topics are of direct interest to this organization. Well, it's not yet been the resolution which is going to be introduced on the 8th of December or 9th of December, depending on the progress of the celebratory part, has not yet been adopted. But I don't think that I am disclosing a major secret if I tell you that the next year topic of the informal consultative process, which assists the General Assembly in the annual deliberations on ocean law of the sea, will focus on new maritime technologies, challenges and opportunities. And this brings us, of course, directly to the issues which are relevant to this organization, also in context of autonomous surface ships, for instance, and other issues. So we look forward to working together with this organization of preparing the report of the Secretary General for this process and also for active participation of the International Maritime Organization in the next year of the informal consultative process. Well, the last thing that I wish to address, well, there are two of them or three of them. It's the cooperation in the field of capacity building. Of course, we cooperate very closely with the International Maritime Organization, especially in the context of supporting member states. One of the examples was, for instance, cooperation in the context of supporting Somalia a couple of years ago. And I'm going to be reminded that I should start wrapping up. Last process that is of great interest to this organization is the conference that I've mentioned, the BBNJ conference. Its next session, or resumed fifth session, will start on 20th of February and for 2 weeks until the 3rd of March. This conference, of course, deals with a number of issues, but of particular interest to IMO would be the area-based management tools, including maritime protected areas, issues related to environmental impact assessments, and of course, again, coming back to capacity building, supporting our clients in terms of capacity. It's a very important task that we face together with our partners, and of course, we intend to fully cooperate in this regard in the future. It's very important that the UN acts as one. For this, we have this UN Oceans mechanism, and we want member states and the representatives being aware that behind the scenes there is a strengthened cooperation of the secretariats of the organizations. And with that, I would like to again thank the Secretary General and my colleagues from IMO for this opportunity. Thank you.
Thank you very much, Vladimir, and it certainly is exciting news to hear that the theme for UNCLOS may focus on technologies. We here at IMO, of course, our World Maritime theme for this year was New Technologies for Greener Shipping, so we may have some logos and pins that we can share with you. The next panelist is Fernanda Milique, who will be discussing the IMO UNCLOS relationship from the member state perspective. The floor is yours.
Thank you very much, Director Kenny. Thanks to the Secretary General, the Secretariat for the invitation. It's a great honor being one of you sitting on the other side. And talking about pins, I'm wearing mine from the 30th anniversary of UNCLOS. But I wanted to share, I don't know if we have a PowerPoint presentation. It's going to be only 3 slides, but to try to illustrate is what I have now the hat of the delegate to the IMO, but I had the hat of a delegate to New York, negotiating law of the sea. I personally identified as some challenges from the perspective of member states in the implementation of UNCLOS at the IMO. The Secretary General already referred to the fact that UNCLOS has a constitutional nature, has been called the Constitution of the Oceans. And not only UNCLOS itself, but also, and Mr. Yaris already referred to the yearly adopted resolutions of the General Assembly on Oceans and the Law of the Sea, have recognized that UNCLOS regulates all activities taking place in the ocean. So the manner in which IMO is taken into account by UNCLOS is very clear, is something that is called the rule of reference. And if you look at the name IMO in the convention, it's mentioned only once in Annex 7. But there's many, and Mr. Yaris already made reference to that, many citations of the competent international organization. So at least 35 times the competent international organization in UNCLOS refers to the IMO. So the question for member states, and this is the first challenge I would like to refer to, is to identify how far the rule of reference goes. Basically, what is IMO called to do under UNCLOS? Because IMO also has to work in the framework of UNCLOS. So if you look at the slide, the way in which the language of UNCLOS refers to the IMO is that the competent international organization, in this case the IMO, will issue recommendations on traffic separation, that IMO will adopt generally accepted standards. The formulation is in charge of the formulation or elaboration of international rules, standards, and recommended practices and procedures, always consistent with the convention. It's in charge also, like other competent international organizations, of cooperation, the promotion of development, of the transfer of marine technology. Now we're talking a lot about that in the framework of GHG emissions. And of course, regulations for safety of life at sea. Could we go to the next one? Thanks. So the question of to what extent the rule of reference allows IMO to regulate and where it stops, let's say, where in a particular issue we need to go back to the parties to UNCLOS, is of great importance, and it's a delicate matter. And I'll give you an example of cooperation in the high seas for fishing. That is something of the recognition of FAO in the Law of the Sea Convention. Nevertheless, for the development of new rules applicable to species of fish in the high seas and in the EEZ, there was the need to develop a new instrument, and that was done by the parties of UNCLOS and members of the General Assembly, and that is the Fish Stocks Agreement of 1995. So two particular cases that I would like to refer to with regard to the IMO. The first one, and I think that the chair of the legal committee will make reference to, is mass ships and manned ships. And basically here we have a particular rule of UNCLOS, which is that the flag state is in charge or has to ensure the manning of ships. So here the challenge lies in the fact, and I've been very eloquent about this in the MSc, if we can ensure that, how to ensure that those vehicles that are not manned, according to UNCLOS, do enjoy the rights of manned ships. So clearly when a vehicle is totally unmanned, maybe there is something that we need to consider, which is what is the appropriate forum, because here there is no rule of reference to the IMO as to the manning. So one possibility would be to deal with it at the meeting of state parties to UNCLOS. Another possibility would be to get an agreement to request an advisory opinion from the Tribunal for the Law of the Sea. Another case is the definition of piracy. Here, as well as the United Nations, there is always reference for practical purposes to piracy and armed robbery against ships. But we need to have a clear idea that piracy is already defined in UNCLOS, in Article 101, while armed robbery at sea is not something that we can define, because according to UNCLOS is subjected to the exclusive jurisdiction of the coastal state. Basically, it's going to be defined by its penal code. The second challenge that I would like to present to you is when the IMO is faced with other norms of international law, including the UN Charter, that are already safeguarded in UNCLOS. And again, continuing with piracy, Mr. Yares mentioned the latest meeting of the Security Council regarding piracy. Here there is an important element, which is the intervention of the Security Council. The situation of Somalia, to which reference has been made in this forum many times, has taken place or has evolved in the framework of Chapter 7 of the UN Charter, which means that is a mandatory resolution of the Security Council. The Security Council, in the case of Somalia, decided to override other rules of international law in accordance with its Chapter 7 of the Charter. In this case, the rule of international law is the exclusive sovereignty of the coastal state within the 12 miles by authorizing action by other states. The question is, if you look at the slide, the Security Council itself made a safeguard that this situation and the rules specific for this situation in Somalia are not transposable to any other situation, and therefore UNCLOS fully applies to other situations with regard to piracy and armed robbery at sea. Another example that I would like to present is the case of the recent adoption by the MSc of a resolution on unsafe migration by sea, in which case the IMO itself introduced a safeguard to other rules of international law, in this case, refugee law and human rights law that are of application irrespective of the standards adopted by the IMO. And the final case that I would like to present to you is something that normally happens in our work, which is when the Law of the Sea Convention identifies for a particular clause or rule more than one competent organization. So, and that is very usual. Already in 1996, in this Law of the Sea Bulletin issued by the DOALOS, the Division for Ocean Affairs of the United Nations, there is an identification of all the competent international organizations for the purposes of every rule of reference contained in UNCLOS. There are important overlaps, and just to mention some, with regard to pollution by plastics at sea, we need to deal also with fisheries. And we need to have it clear, and that is normal, an exercise that we undertake, where the competence of the IMO lies and where the FAO should come into play, because that's the regulation of the fishing activity. The same goes for the question of communications, for safety of navigation, and the coordination between IMO and the ITU. So as a conclusion, and as a representative to the IMO, but that comes from Law of the Sea, I would like to stress that I've come to recognize that although the conceptual framework of UNCLOS is to be followed at the IMO, there could be a challenge. We are delegates to the IMO. We are accustomed to dealing with the rules of the IMO. Not necessarily we come from the Law of the Sea. Not necessarily we deal with UNCLOS all the time, and not necessarily the authorities that give us instructions deal with UNCLOS. So that is a challenge. And recognizing that, nevertheless, maybe this 40th anniversary could inspire us to reflect on the importance of preserving, within the work of the IMO, a convention that, as Director Jares said, is one of the international instruments with the clearest economic, strategic, and political implications. And not only parts of the Secretariat, but also member states, and we are all parties to UNCLOS also, act as one. Thank you very much.
Thank you very much, Fernanda. And now to the final speaker on the first panel, Judge Hayter, the floor is yours.
Secretary General Kita Gleam, Director Fred Kenny, delegates, ladies and gentlemen, I always prefer to stand if at all possible. I would like to thank the International Maritime Organization for organizing this event and for inviting me to participate in it. In my rather short intervention, I will address UNCLOS at 40, IMO, and UNCLOS, and how they relate to one another from the perspective of maintaining UNCLOS as a living instrument. As we commemorate the 40th anniversary of UNCLOS, two observations may be made. First, during the past 4 decades, there has been considerable advancement in scientific knowledge and technology in a number of fields addressed in the Convention, including, quite relevant in this forum, shipping. Autonomous shipping presents a good example. Second, fundamental environmental changes are taking place as a consequence of global warming, including sea level rise in particular. Obviously, these developments pose challenges to the Law of the Sea framework, and the question is, how do states and international organizations cope with these challenges? What are the possibilities for adapting the legal framework to those challenges? Let me make 6 brief points in this regard. First, the Law of the Sea Convention provides formal amendment procedures. But to cut a long story short, the Convention has never been amended pursuant to those procedures. The reasons are probably twofold. On the one hand, it may be difficult to achieve expeditious adoption and, in particular, entry into force of formal amendments to the Convention, given the stringent requirements therefore. On the other hand, states parties are likely hesitant to propose amendments, as it may open the door for other amendments and risk undermining the package deal that UNCLOS represent and that Director Jares referred to before. However, and this is my second point, 2 so-called implementing agreements, the 1994 Part 11 Agreement on deep seabed mining and the 1995 UN-FISTOS Agreement, have de facto modified or amended the Convention or the Law of the Sea framework more generally. Currently, a 3rd implementing agreement under UNCLOS is taking place, is being negotiated, the so-called BPNJ agreement. it is quite probable that this new agreement, which is quite relevant to the IMO, will go beyond mere implementation like its two predecessors. Third, the Law of the Sea Convention includes several other mechanisms through which its adaptation may take place. It provides, for example, for the obligation of states acting through competent international organizations to establish relevant international rules and standards in different areas. In many cases, the rules and standards adopted by these organizations are incorporated by reference into the convention regime, the so-called rule of reference. A primary example of such competent international organization is, of course, IMO, and I will revisit it in a minute. The UN General Assembly, the meeting of states parties to the Convention, and the International Seabed Authority are among other institutions that are relevant also in adapting the Law of the Sea framework to new developments. And number 4, other agreements between states, including bilateral and regional agreements, provide an important part of the Law of the Sea framework. Fifth, state practice and development of customary international law can play an important role in adapting the Law of the Sea to changing circumstances. In some cases, such an approach may be preferred to that of formal amendment procedures or the negotiation of a new instrument. The legal effects of sea level rise due to climate change, currently under the consideration of the International Law Commission, may potentially represent such an issue. And finally, sixth, international courts and tribunals may clarify and develop the Law of the Sea framework in light of new scientific and technical knowledge and changing circumstances. The main task of UNCLOS under the Convention is, of course, to settle disputes concerning the interpretation or application of the Convention. However, in some cases, the Tribunal may have an opportunity to clarify the Law of the Sea, which not only benefits the parties to the relevant case, but also the international community as a whole. I will return to UNCLOS after a few remarks on IMO. UNCLOS has been referred to as the Constitution for the Oceans. In many areas it provides general principles and is complemented by other agreements and instruments that together form the relevant legal framework. As you know, IMO is the preeminent international organization with competence to establish international rules and standards for the safety, security, and environmental performance of international shipping. Therefore, in matters relating to international shipping, UNCLOS outlines the rights and obligations of states parties in various maritime zones that must be exercised and fulfilled through implementation instruments under the auspices of IMO. Interestingly, although IMO and its predecessor IMCO had existed for decades before UNCLOS was concluded and before it entered into force, IMO instruments, both those pre-existing and those subsequently developed, now operate within the framework of UNCLOS. When developing international rules and standards under its mandates, IMO must ensure that they conform with the basic principles set out in UNCLOS. There is only one direct reference to IMO in UNCLOS, in its Annex 8 on special arbitration. However, it is generally recognized that references to the competent international organization, as it is put, in UNCLOS provisions relating to international shipping and vessel pollution refer to IMO. As Fernanda said earlier, there are more than 35 provisions in UNCLOS that refer to international rules and standards established by IMO instruments. These phrases are not used consistently. There are many different phrases, but more than 20 of them are used to serve the purpose of incorporating complementary international instruments into the legal framework of UNCLOS. In particular, the phrase generally accepted international rules and standards. Arguably, not only legally binding instruments, but also non-binding instruments may be incorporated into the Law of the Sea Convention under the rules of reference. In his separate opinion in the 2015 UNCLOS Advisory Opinion on IUU fishing, my colleague Judge Peck explained the rule of reference in the following manner, quote, one of the consequences of employing the rule of reference is to impose legal obligations on a state to apply certain rules and standards which it would otherwise not have been legally bound to apply. In such a situation, the rules and standards apply to the state not because they are legally binding as either treaty or custom, but because they are incorporated into the Convention through the rule of reference." Unquote. Such incorporation enables the states parties to UNCLOS to comply with rules and standards that evolve over time to meet changing environmental needs and technological advancements. The dynamic relationship between UNCLOS and IMO allows the legal framework to evolve and respond effectively and flexibly to new challenges and developments. Turning finally to UNCLOS, in its 26-year history, 30 cases have been submitted to the tribunal. It is interesting to note that 2/3 of these cases, 20, have related to the arrest and detention of ships. That is 10 prompt release cases, 5 provisional measures cases, and 5 cases on the merits or substance. In the MV Saiga No. 2, MV Virginia G, and MV Northstar cases, the flag state claimed compensation for damage arising from the arrest and detention of the ship in question. The tribunal had the opportunity to clarify the unique nature of a ship as a unit, a finding that has a particular relevance for the right of the flag state to seek redress for the ship's crew members and other persons involved in its operations who are not its nationals. And I should add that in such cases, the tribunal has highlighted that considerations of humanity must apply in the law of the sea as they do in other areas of international law. When dealing with cases relating to shipping or vessel pollution, UNCLOS will apply the relevant provisions of UNCLOS, including generally accepted international rules and standards, which have been adopted by IMO and incorporated into the Convention through rules of reference. The tribunal must then identify those rules of standards and assess whether they may be considered to be generally accepted, which would very often be the case. In addition to contentious jurisdiction, that is, jurisdiction to deal with disputes, the tribunal also has advisory jurisdiction. Advisory opinions serve to interpret and clarify the relevant provisions of the Convention, related agreements, and other international law. The tribunal has rendered an advisory opinion on IUU fishing, and the UNCLOS Seabed Disputes Chamber has issued an advisory opinion on obligations of states sponsoring persons and entities with respect to deep seabed mining. Advisory opinions may be a particularly suitable means to clarify the law of the sea in light of new scientific findings, technical advancements, and changing environmental circumstances due to climate change. The tribunal stands ready to apply its advisory jurisdiction and assist member states of IMO when questions relating to the interpretation or application of UNCLOS arise in their work. By way of conclusion, I think it is fair to say that the Law of the Sea Convention, Act 40, is very much a living instrument. IMO plays an imperative role in adapting the relevant legal framework to new developments, and UNCLOS plays its part by taking such developments into account when interpreting and applying the provisions of UNCLOS. Thank you very much for your attention.
Thank you, Judge Hader. And I want to thank all the panelists on this first discussion. I think what we got was a very comprehensive, somewhat global view of where we are right now. And what I'd like to do next is turn it over to the moderator of the second panel, Dorota Lastrumenska, who will moderate a panel on where we are going. Dorota?
Thank you very much. Thank you to all the speakers so far. It was indeed very, very interesting and very good overview. And as Director Kenny said, now we will be looking more into the future of cooperation between IMO and UNCLOS, and what challenges we will have to address. So our first speaker is Judge David Attard. It is my pleasure to invite Professor Attard to give his remarks. Thank you.
Secretary General, distinguished delegates, panelists, I am indeed honored this evening to be invited to address you in the celebration of the Constitution of the Oceans, which was first promoted by Malta in the late 1960s. UNCLOS, with its 168 parties, has created a legal order that has benefited humankind. Before I give you or share with you my thoughts, let me make it clear that these are personal thoughts which are based largely on my experience working with IMO since 1988. The first point I wish to make is the universality of UNCLOS and its effect on state practice. Even those that are outside the Convention find it forceful in their maritime relations, to say the least. Indeed, it's probably worth recalling that the effect of the Convention has led to new institutions. Reference was made to the package deal, which have changed the whole spectrum of international maritime law. Indeed, possibly it's worth recalling that the work at the UN influenced state practice even before the Convention was adopted. We have states relying on the UNCLOS informal text to promulgate their exclusive economic zones. But the Convention, with its delicate checks and balances, has now been tested for 40 years. And I would say that it is to stay with us for decades to come. And in this respect, it is a reality which will continue to influence its relations with IMO. The drafting history of the Convention shows that many of the rules in the Convention were drafted in the late 70s. The provisions of the treaty reflect the challenges of the oceans in those years. To a great extent, the rigidness of the UNCLOS amendment process, as we have heard, and the outstanding developments in ocean technologies and the great environmental threats require constant response strategies that must come inter alia, primarily, in fact, from IMO. In this respect, it is my opinion that IMO has an important, vital role in the progressive development and codification of international maritime law within the framework of UNCLOS. An important factor that has contributed to IMO's success is its universality. In fact, more member states than UNCLOS, representing all the regions of the world where states are able to participate in meetings of IMO bodies responsible for drafting prescriptions on important issues. Significantly, these prescriptions are normally adopted by consensus. IMO, in my view, has today become the leading institutional source of international maritime law. Responsible, as we have heard, for over 50 conventions and literally hundreds of rules and prescriptions that ensure safer seas and healthier oceans. In fact, it should be recalled that an intensive maritime treaty-making activity was in progress at IMO well before the establishment even of UNCLOS. In fact, by 1982, important IMO treaties such as SOLAS, MARPOL, STCW had been adopted and had attracted considerable acceptance. Also, I believe it is fair to pay tribute to the IMO, formerly IMCO officials, who between 1973 and 1982 contributed to the work of UNCLOS III in order to ensure that the drafting of IMO instruments conformed with the basic principles guiding the drafting of UNCLOS. This effort ensured harmonization of IMO's and UNCLOS texts and resulted in the practice of including in IMO conventions provisions designed to ensure they do not prejudice the rights and obligations under UNCLOS. Distinguished guests, as has been pointed out, throughout UNCLOS one finds numerous references to the competent international organization and its rules. If we look at the example of COLREG, we see that UNCLOS, without actually referring to IMO by its name, refers to COLREG in its different maritime zones: territorial sea, straits used for international navigation, the high seas. In my view, the incorporation of IMO regimes ensures that the future of UNCLOS is intimately linked with IMO's work, as confirmed by general support of state parties for the IMO rules and standards on safety, pollution, training, and certification. Conversely, the UNCLOS regime is carefully grafted into IMO treaties to ensure that they do not alter the rights and duties under UNCLOS. Ultimately, IMO instruments are adopted within the framework of UNCLOS. The incorporation of IMO prescriptions also has merits for ensuring that the UNCLOS regime is able to deal with contemporary issues developing years after its adoption. This is a temporal safety mechanism which relies on the work of IMO to ensure that UNCLOS rules are updated to deal with the new challenges. The duty of UNCLOS state parties to apply IMO rules and standards can also be seen as another incentive for states to become parties to IMO treaties. For as parties to these treaties, they would be allowed specific entitlements in accordance with the precise treaty law provisions, as the case may be. Paramount amongst these would be the value accorded by state parties to the IMO treaties for the certificates issued pursuant to these instruments. Also important would be the right of state parties to participate in the deliberations taking place under the IMO treaties and having the right to participate in future treaty amendments. The influence of UNCLOS will continue to be reflected, however, in the work of IMO. And indeed, we see the adoption of UNCLOS rules as part of IMO treaties. SOLAS refers to UNCLOS in Chapter 5, Regulation 10. It appears to me that this intimate relationship will continue to grow. There are, in my opinion, areas of law that are immature to deal with the contemporary problems and require legal responses. IMO is an important institution in ensuring that UNCLOS continues to take into account the contemporary problems that we face. On a personal note, I wish to consider that we should not forget the important role that the IMO Secretariat plays in this relationship. The Secretary General has an influential position which may encourage the organization to focus on particular legal strategies. In this respect, I remember discussions with the Secretary General relating to two issues, Article 91 of UNCLOS and port state control. One should also refer to the committees of IMO, which I consider to be the censors of IMO. In this respect, of course, the legal committee has a very important function, and I leave this to the chairman. Yes, I will come to my end, Mr. Chairman. I was actually going to refer to your position, so perhaps you will give me 1 more minute. The point I want to make also is that in this process, the division of the IMO Legal Affairs has an important role. I have had the privilege of working with its director since Tom Mensah in 1988, who later became the first UNCLOS president. I particularly wish to recognize the work of the current director, Mr. Kenny, who in the tradition of his predecessors for many years has been offering valuable legal advice. Finally, as we know, these treaties have to be enforced. IMO has no enforcement powers, with one exception, and therefore importance must be given to capacity building, and I'm proud that IMO saw this problem and dealt with it through the establishment of IMLI in 1989. Thank you very much.
Thank you very much, Professor Attard, for your very powerful message, which we will certainly take into account in our future work. And as you said, the convention, the UNCLOS, is to stay with us for decades to come. One of the challenges that we will be facing are those related to the environmental threats, as you rightly also pointed out. And now I would like to invite Professor Małgosia Fitzmaurice to share her views on the future challenges.
Thank you very much, first of all, for inviting me here, Secretary General, Director Henry, Dr. Lost. Thank you so much for inviting a humble academic to participate in this very important conference. So my presentation will be divided into parts. First part on protection of marine environment, which will say how it is now, and then the second part I will try to make some postulates for the future, how it is maybe developing. So part of my presentation, the first part, will also very much relate to my predecessor speakers already mentioned, like the rule of reference. So first, let's start with Article 192, which is the general article of UNCLOS, general obligation, very succinctly put, states have the obligation to protect and preserve the marine environment. Obviously, it is well known that this obligation to generally protect the environment is the due diligence obligation, and this is also the background of the Article 192. And again, we are coming to the same formulation, a competent organization, which in relation to protection and of the marine environment is the IMO. I would also like to mention that in my view, also as an expert on the law of treaties, the formulation of certain provisions of UNCLOS are a masterful example of drafting, because it looks in the past and it also looks to the future. The Article 197 mentions again international competent organization in formulating and elaborating international rules, standards, and recommended practices. So we are now again in the sphere of the rule of reference. The articles on Part 11 on the protection of the environment have several standards: generally accepted international regulations, procedure and practices, international rules and standards, generally accepted international rules and standards, and applicable international rules and standards. And what I would like to mention is that this is what I call the masterful codification of the law of treaties, because when the UNCLOS was negotiated, then already was linked in relation to existing rules and standards, but also looking to the future. States are supposed to follow evolving and developing rules of standards in relation to protection of the environment. So we can say that the approach of UNCLOS in relation to rules and standards is this of UNCLOS and the role of IMO developing approach of a treaty as a living instrument. So we can say that what we call in the law of treaties evolutionary progression of the treaties is really incorporated in the UNCLOS. So to give the example, Article 218, pollution from vessels, states acting through competent international organizations shall establish international rules and standards to prevent, reduce, and control pollution of the marine environment from vessels. And then such laws and regulations shall at least have the same effect as that of generally accepted international rules and standards established through the competent international organization. So we know that it refers to MARPOL Convention, which is a global convention. But these rules and standards, again, have to be adopted by states as well developed. So it's not a static procedure, but it's very much evolutionary approach to the law of treaties, which I think is very important. That UNCLOS, through its very masterful drafting, managed to express the way rules, international rules of standards, which are formed under auspices of the IMO, are given effect by the practice of states. The same example can be Article 210, pollution of dumping, which really refers through the rules of London Convention and the London Protocol. So, as it stands now, IMO, through its evolutionary approach to treaties and also through its establishment of special areas and especially and particularly sensitive areas, I think it's very much equipped to look for the future. Why? Because it gives a very flexible framework of future development. So this is as it stands now. So as it stands now, as I say, it's a very flexible, very elastic, very accommodating structure to approach all the changes in protection of the marine environment. And now I would like to come to some postulates for the future. So this also draws from the general changes in approaches to protection of nature. First of all, I would like to make a link that environmental law, i.e. also including marine environment, is now very much related to human rights, which especially was emphasized by the resolution in July of the General Assembly on general human right to clean environment. However, we are going already further, and in especially Latin America, which is leading in environmental legislation, we already have new ecological direction, i.e. rights of nature. It was the first time in the world when Ecuador acknowledged the rights of Mother Earth, Pachamama, and it was constitutionally granted. Now it was also amendment of the Constitution which gives rights of nature to rivers, mountains, forests, and islands to give them right to exist, flourish, and evolve. A similar approach or development we see in other states, Colombia, but also New Zealand, which accord to rivers the legal personality. So, for instance, River Atrato in Colombia is now a subject of rights, and also these rights can be enforced by the guardians. So it's not really a fiction, but it's a real legal development that guardians can protect rights of the rivers before the court. And there were already cases of this kind against certain companies which were which the court decided were actually violating the rights of nature. So how does it relate to the role of the IMO and oceans? Well, I think that the structure of UNCLOS and IMO can give rise to certain movement to give the legal personality and rights to oceans. And there is an initiative which is called Declaration of Ocean Rights, which is similar to Universal Declaration on Human Rights, which would give oceans and ecosystems legal personality status. Then it would lead to defending the environment of oceans against environmental degradation before the courts, and it also could appoint special guardians in order to represent the rights of oceans. And I think that there is already an environmental background in various rules and principles, such as the precautionary principle, environmental impact assessment, intergenerational equity, to give the thought of such a development. I would like to, ladies and gentlemen, to turn your attention specifically to the intergenerational equity principle, which it was first formulated by Professor Brown-Weiss. It was accepted with certain degree of doubt. However, as the judicial practice proved, and the practice of domestic law, this became reality. And there are several cases before international tribunals and national courts which bring the cases on behalf of future generations. I would also like to mention that in many constitutions of states, like Hungary, there is a position of ombudsman for future generations. So what was considered to be not a very practical approach became the reality. Therefore, I am postulating that perhaps states should consider granting legal personality to oceans and seas, and also accord them guardianship in order to bring their rights, violation of their rights before the courts. Thank you.
Thank you very much, Professor Fitzmaurice. It will be very interesting indeed to see how IMO will incorporate such ideas in its future work. As was already mentioned, the legal committee also plays its role in the context of cooperation with UNCLOS, and there are several agenda items that the legal committee considers which are very relevant for UNCLOS. And now I would like to invite the chair of the legal committee, Ms. Gillian Grant, who is joining us today from Washington.
Thank you very much, Dorota, and it's a real pleasure and honor to be a member of this panel. I also recognize that as the last speaker, I am all that stands between you and a drink, and also those delicious cheesy jalapeno poppers that the IMO serves at receptions, which I miss, although probably my waistline does not miss so much. But my task is to look at the future of IMO's relationship with UNCLOS. And as Dorota mentioned, I'd like to do that through considering two issues which are currently before the legal committee. And those are fraudulent registration and maritime autonomous surface ships, or MAS. However, before I get to those examples, and so that I can properly situate them, I'd like to start with a quick overview of the UNCLOS framework, particularly when it comes to the rights and responsibilities of flag states. So as several speakers have said, UNCLOS is an umbrella convention that establishes broad commitments and principles regarding marine activities and oceans governance. Article 87 establishes the freedom of the high seas and the right of all states to freedom of navigation. However, to ensure the responsible exercise of this freedom, UNCLOS provides a framework for the regulation of shipping that rests on two core principles. The first is that each state must fix the conditions for granting nationality and the right to fly its flag, which is in Article 91. And the second is that states must exercise effective jurisdiction and control in administrative, technical, and social matters for ships flying their flags, and that appears in Article 94. So, as several others have said, UNCLOS sets out general requirements that flag states must meet to ensure effective control over their ships. And this includes that ships must follow generally accepted international rules and standards. As several of my colleagues have said, UNCLOS leaves the development of many of these rules and standards to the competent international organization, which for shipping is the IMO. UNCLOS is difficult to amend, as Judge Hader indicated. However, the competent international organization model and IMO rules allow the convention to keep pace with technological developments and to be evergreen. And here I'd just like to note IMO's tacit amendment procedure is particularly important for this purpose, as it allows widely ratified base conventions, such as SOLAS and MARPOL, to be amended quickly following adoption of the amendments by the relevant IMO committee. So with that background, let me turn to a specific example before the legal committee. The first is fraudulent registration. And as I mentioned, Article 94 requires every state to exercise effective jurisdiction over ships flying its flag. And this process begins with the registration of the ship. Registration of ships and flag state oversight through surveys and certification contribute to the safety and security of maritime transport and the protection of the marine environment. There is currently no internationally binding framework to regulate registration of ships, so each country sets its own requirements. And I'd say that mostly this works well, and the IMO has developed a broad system of conventions, regulations, guidance, and programs, such as the Member State Audit Scheme, the Continuous Synopsis Report, and harmonized port state control measures to support effective flag state oversight. Unfortunately, the system is not perfect, and there have been several recent examples of fraudulent registration where illegal actors purport to register a vessel in a flag state without the knowledge or approval of the state's National Maritime Administration. And indeed, I believe we had an example just last week with Georgia. Fraudulent registration impedes effective flag state oversight. Certificates on board these ships are not legitimately issued by the flag state, and the ship is likely not in compliance with safety and environmental protection standards. This endangers the vessel's crew and increases the threat of damage to the environment. Lack of effective flag state oversight allows fraudulently registered ships to be used for illicit activities such as sanction avoidance and IUU fishing, and threatens the whole regulatory regime established by the IMO and under UNCLOS. Fraudulent registration also unfairly damages the reputation of states that are victim of the practice, especially if the ships are used for illegal activities. IMO has over the years taken a number of measures to prevent fraudulent registration, and I outlined some of them. However, the practice continues. And in 2017, the Democratic Republic of Congo brought its experience of some 73 improperly registered ships to the legal committee and asked for urgent action to address the problem. Several other countries have subsequently come forward, and since 2018, the legal committee has developed a series of resolutions, best practices, and a GISIS module to assist in combating fraudulent registration. Just at the last legal committee meeting this year, Leg 109, the committee commissioned a study from IMLI, UNCTAD, and WMU on fraudulent registration, which is due in 2024. This study will look at the current scope of the problem, national best practices, potential preventive measures, and will be used to inform future work and measures, at least I hope it will, it's up to member states, obviously, to effectively root out this scourge. To conclude on fraudulent registration, I'd say that it demonstrates the important link between UNCLOS navigation rights and the IMO regulatory regime, which ensures that these rights are exercised safely and responsibly. It also illustrates the ongoing relevance of IMO's work to the integrity of the UNCLOS regime. So I'll now move to my second example, which are mass. So there's no single agreed upon definition of mass, but it includes two concepts, which is first, the relocation of crews off of ships, and second, enhanced automation on board ships. I think it's fair to say that mass are a disruptive technology that challenge the existing regulatory framework, which is based on human presence and control. A preliminary question, and it's one that my colleague Fernanda raised earlier, is whether UNCLOS and the existing legal framework can accommodate mass. The biggest challenge, as Fernanda pointed out, relates to flag states' due diligence obligations in UNCLOS, and in particular, the requirement in Article 94 for a ship to be in the charge of a master and a crew who are properly trained. So Fernanda gave one perspective on this issue, and it's a very controversial one. There is another perspective that's mooted by some academics and commentators, which is that while mass pose challenges, they can be accommodated under UNCLOS. And their argument goes something like this. They say that UNCLOS is a framework convention which should not be construed as preventing the introduction of new technologies. And they note in particular Article 94.5, which states that flag states in exercising their obligations under Article 94 are required to give or to conform to generally accepted international regulations, procedures, and practices. They would say that the structure of UNCLOS as a framework convention and the concept of the Confident International Organization allow for the evolution through the IMO developing regulations to ensure the safe, secure, and environmentally responsible operation of new technologies. I'm going to continue with this argument, but I'll sum it up soon. The IMO's corpus of widely ratified base conventions and the tacit amendment procedure leaves it well placed to develop a regulatory for mass quickly. And indeed, I think that this process would be quicker than trying to come up with an amendment to UNCLOS or some kind of implementing agreement, or indeed a standalone convention. IMO delegates possess the technical expertise to assess what will be necessary for mass to operate safely and securely. But, and this is a really important but, Masks are a paradigm shift. And so while there may be an argument that IMO can regulate them, any work that IMO does on masks must be cognizant of and respect the UNCLOS framework. If masks are to operate internationally, UNCLOS obligations will need to be interpreted in a broad and liberal manner, consistent with the object and purpose of the convention, and IMO will need to develop a regulatory regime to address gray areas and gaps, especially at the flag state level. And as many of you in the room will know, the MSC has already started on this work through negotiating a mask code. In my view, if the mask code is to comply with UNCLOS, it will need to provide explicit guidance on a number of areas, and I'll just name a few, but there are many more. So first, how effective control of the ship will be maintained if there is no master and crew on board. Second, the roles and responsibilities of remote operators. And third, but by no means last, how flag states should maintain effective oversight over remote control operation centers outside of their jurisdictions. To ensure compliance with UNCLOS, technical and legal experts must work together at IMO. And here I'm very pleased with the establishment of the joint working group of the MSC, LEG, and FAL committees, who are tasked with looking at overarching issues and also in trying to work out some of the legal issues that I've addressed or I've identified today. And finally, and this is also very important, IMO will need to keep its partners in other relevant UN organizations apprised of its work and indeed involve them in the negotiations. So I guess I'm concluding briefly on masks, I would say that they have arrived and are here to stay, although they are not trading internationally extensively at the moment. If the international community is not proactive, technological change and commercial developments will determine how they operate. Failure to act on masks, in my view, will lead to questions about their legality and the patchwork of national regulations, which is not in the best interest of maritime safety or the marine environment. It may also undermine the relevance of the UNCLOS regime and IMO's credibility as a regulator. So in my view, IMO has recognized that it needs to act through the regulatory scoping exercise and the development of a new mask code and also new work at the FAL and LEG committees. But the challenge will be to conduct this work in a way that conforms with UNCLOS. And this will require, as I said earlier, close contact between lawyers and technical experts and between the IMO and its partners in other UN organizations. So you'll be very happy to know I'm drawing to a conclusion. So I'd just like to say with both of the examples that I've spoke about today, I think both fraudulent registration and masks demonstrate that UNCLOS is a living instrument and underline the important dialogue between the Framework Convention and the IMO regulations. UNCLOS empowers IMO to develop a regulatory regime for ships that will meet the objectives of the convention and allows this regime to be constantly and efficiently updated. Fraudulent registration and masks point out both the challenges and the opportunities of this model. In the case of fraudulent registration, IMO must be reactive and address gaps in international regulations to root out illegal practices and maintain confidence in flag states' oversight and the UNCLOS regime more generally. In the case of masks, IMO has the opportunity to be proactive and to adapt UNCLOS to accommodate a novel technology, but it must act with caution. Neither issue is easy, and both will require IMO to draw on its expertise and creativity to leverage its partnerships with other members, and to leverage its partnerships with other members of the international community. Both examples provide excellent opportunities for IMO to demonstrate its relevance and value 74 years on, and after 40 years at the heart of UNCLOS. Thank you.
Thank you very much, Gillian. It certainly looks like we have a very, very busy future before us. And I now would like to turn the floor to Mr. Kenny, please.
Thank you, Dorota. I did say we'd have time for Q&A. I'm going to read that clock because it says we haven't hit stop time yet. So if you have any questions from the floor, I'd be happy to entertain them. I think we can take them from hybrid participants as well. If you want to just raise a card, if you have a question for any of our panelists. Mexico, please.
Thank you. Thank you very much to all the panelists. I think it was very, very illustrative for me that I'm not an expert in UNCLOS. But since we have no time, I'll go quickly to the question. And I think I would like to ask Judge Haidar, am I pronouncing it right? Vice President of the UNCLOS, and particularly regarding the advisory opinions of UNCLOS. What are the requirements that a state has to fulfill in order to submit an advisory opinion or a request for an advisory opinion? And if those advisory opinions are not legally binding, can they still have any legal effect? Thank you.
Thank you, Mexico. Judge?
Thank you very much for a very interesting question. We have a rule in the rules of the tribunal on advisory opinions. It's rule Article 138, which says that the tribunal may give an advisory opinion on a legal question if an international agreement related to the purposes of the convention specifically provides for the submission to the tribunal of a request for such an opinion. So there are basically two main requirements. First is that these have to be legal questions, so not policy questions, for example. So typically they would relate to interpretation or application of the Law of the Sea Convention or related instruments. And the second requirement is that there has to be an international agreement. In principle, it could be two states that would make a bilateral agreement among them to submit a request for advisory opinion to UNCLOS, but more typically there would be a group of states doing so. So the relevant example is, of course, from the 2015 advisory opinion on IUU fishing. There were 7 West African coastal states that all were concerned about IUU fishing in their exclusive economic zones. So they formed an agreement, a sub-regional fisheries commission, and they, which had the mandate to ask UNCLOS for advisory opinion, especially on the obligations of flag states in preventing their vessels from engaging in IUU fishing. So that is the primary example. This is the only advisory opinion that the tribunal as a whole has given. The Seabed Dispute Chamber has issued advisory opinion also. There is an interesting recent development. 1 year ago, a few states in the Caribbean and the Pacific signed an agreement which establishes a commission of small island developing states on climate change and international law. And this agreement, which is open to signature of all members of the Alliance of Small Island States, authorizes this commission to request advisory opinions from UNCLOS on any legal question within the scope of UNCLOS. So I believe this is now under consideration by these particular states. There is also the interesting development in the PB&J negotiations that there are proposals there to include in the PB&J agreement a provision authorizing the future conference of the parties to that new agreement to request advisory opinions from UNCLOS. This is not settled, but this is certainly being looked at, I believe, in those negotiations. It's important to have in mind with these advisory opinions that the proceedings before the tribunal are not exclusive, they are inclusive, which means that not only those states that request the advisory opinion have the chance to provide information, to explain their views with respect to these legal questions, but also all states parties to the convention and also the relevant international organizations. So if there were a question in the field of international shipping, vessel pollution, IMO would certainly have the chance to make its views known to the tribunal before the tribunal would render its advisory opinion. And on this last question, it's a bit complicated, but it is true that advisory opinions by definition are not binding, not legally binding, but they can still carry a lot of weight. And it is maybe best to explain it by imagining that the tribunal would be responding to a particular legal question in an advisory opinion. And if that same question were to reappear in Hamburg in another case later, in a contentious case, in a dispute, then it seems quite obvious that it is not likely that the tribunal would respond to that question differently than it did in the advisory opinion. So that kind of gives you the idea that such opinions must carry a lot of weight, even though they are not as such formally legally binding. Thank you very much again for your question.
Okay. I know that people want to get to a glass of wine and jalapeno poppers, and we will, Julian, we will send one to you to Washington. We'll get there. We'll get them there somehow. Get one more question. IMSO, please.
Thank you, Fred. This is my personal question rather than IMSO. It is because of my interest as the former WMU students where we had the 25th annual Law of the Sea conference. It was a long time ago. But we knew that enforcement of MARPOL is a very challenging one. I just like to ask how successful it is now. And can I also ask another question about this? Probably it is an IMO question. IMO member state audit scheme covers about 9 conventions, if I'm correct now. Is it feasible to consider MARPOL as one of the subject matter for member state audit? Thank you.
I would ask, I think I'll ask both Malgosia Fitzmaurice and Vladimir Yaras to answer the first question, if they could. Vladimir, why don't you go first?
I wish I could, but normally in the United Nations Secretariat, we do not comment on member states' actions in implementation of international treaties. This issue is quite sensitive, so I wouldn't dare. But indeed, the issue is here, implementation of all provisions concerning the Law of the Sea Convention regarding environmental protection for pollution of ships. This is an important question. The issue is frequently also capacities, and it's probably no secret that not all states have the same capacities. Hence, our efforts in capacity building on the Law of the Sea side, and also being supported on the maritime law side by IMO. And I would probably stop at that. Thank you.
Well, I know Malgosia as an academic is more free to speak, so.
Yes, thank you very much. Well, I would say that MARPOL is considered one of the success stories in protection of the environment in general. Obviously, I agree with Director Yares that it's a question of capacity building. And definitely it is a very obviously expensive convention because it moves on. For instance, Annex 6 to the MARPOL Convention, which is on protection really of climate change and emission from ships, and it moves on all the time. There are stricter and stricter requirements. There are exclusion zones like the Baltic Sea, and there are three, I think, exclusion zones. So MARPOL requires also reception facilities, some annexes. So it is not an easy convention to follow. However, I would say that due to quite robust enforcement system, it is quite successful. And we need to, I think, divide the implementation of MARPOL generally and within also European Union. Because within European Union, when it is even stricter application, I think it is quite, well, effective and efficient. And I would say that generally, the question of monitoring, the question of cooperation of states, I cannot say it's 100% successful, but if we look at general background of implementation of environmental treaties, I would say it's on par with the CITES Convention on protection, on the trade in wild species of fauna and flora. So I would say it is a success story, but it won't be any convention which would have 100% implementation. And we really need to look at it within the framework of a common but differentiated responsibilities principle and generally capacity. Thank you.
Thank you very much, Professor. I don't see any additional requests from the floor, and I understand there are none from online. So let me wrap this up. I think I'll echo the words of Mexico, where she said that that this was a good educational experience, and I think it was for everyone. It certainly was for me. I learned some things as well. I want to thank all of the speakers for a really robust discussion and for actually presenting so many different perspectives on the IMO relationship with UNCLOS. Many of you are familiar with Leg MISC 8, which is the comprehensive document that describes in detail the relationship between the IMO treaty regime and UNCLOS, if you're looking to do additional reading. We are in the process of updating that now. Our hope is to get that out to you next year. You can find it on IMO Docs under the Legal Committee tab under Leg MISC, and look for the updated version of it soon if you wish to learn more. And for that, I just want to thank you all for your attention and attendance, and we look forward to seeing you upstairs. Thank you very much.
Well, ladies and gentlemen, you're all moving, but this does bring us to the end of our event, and I'd like to now invite you to the Delegates' Lounge for our reception. Thank you. Good also.
So this is down to